Attorney Bederow has a number item.
Mr. Bederow.
Thank you, Judge.
Honestly, go fuck yourself, sir. You don't say that, okay? You don't lose a trial where a jury acquits someone and finds them overwhelmingly not guilty and say, I gave my sincere obligation to look into this, and I'm telling you all I saw when she's guilty. Again, respectfully, go fuck yourself.
Swear again like that. That was, no, I mean, whatever. That was, I shouldn't have done that.
A few moments later.
You, as a prosecutor, have got to be out of your fucking mind.
Nose.
Dude, Jimmy, look at those ears.
The ears don't bother me as much.
No, I don't trust a man. I don't trust a man with a lobe like that. No,
really,
not a fucking chance.
The mouth is butthole to me.
Very thin, paper thin.
The nose.
Oh, the nose.
The brows.
Well, listen, I will tell you though, I kind of like a fucked up nose on a guy.
Like a big old honker. I like a big nose.
Old nose. Give me that big bitch. You know,
yeah,
like, I'm into it.
Come over here, cluck cluck.
Yeah.
I see some chickens that went on up in my biz, cluck cluck. You gotta be with the kids, the kids, the kids, the kids, the kids, kids.
And I go, oop, clutch, clench, kegel. We did it all. And I go, oh, and what happened? And they go, well, we just got 4,000 plus pages, bitch. And I said, stop it. Show me it. Take me to Unimpound Town immediately, if not sooner. So what happens?
The bitch is here.
Why are you at a football game? Are you a Fonz correspondent?
Well, no, because it's only for men over 30. Okay? Have a great night, boys. Fuck off.
It's been 1 week since you looked at me.
Hey, Blues Clues, motherfucker.
Good morning, loveys. Happy Sunday. It is September 28th, 2025. And I am late. And I had technology issues this morning. And Mr. Bederow is living on a prayer and saying to himself, oh, get your shit together, Kimberly Jean. It was said it was. So now it's together. Hi. And without further ado, our emotional support attorney, our best friend from out of town, and our Patriots legend is with us, Mr. Bederow.
Hi.
Good morning.
Seriously. 8 a.m. is 8 a.m. Come on.
Listen.
I've got shit to do before 1 o'clock. Come on.
I know you do. And your time is valuable. And I don't know who or what the gods were trying to do to me, but I'm never late like that.
Okay.
I'm sorry. Please forgive me. I know not what I do. Okay. When the technology goes down, Mr. Bederow, I'm lost. I'm lost in translation. I don't know. I go, it says, oh, you have to restart. I was in the thing. It said, you got to get out of the thing. I get out of it, but fair assessment on your part. I wasn't there early enough. Do you know what I'm saying? Because this all happened around 7:55. And then now it's 15, 18, 20 minutes late. And that's what happens. A reboot with a laptop, is different, I think, than a reboot with the desktop, but I don't know how to get into it on the laptop. So neither here nor there. I apologize. And I appreciate you.
A lot of word salad just to say you're late.
Just say you're late. Okay, done and done. So anywho, let's jump right into it because we don't F around. How are you? Are you good?
Well caffeinated.
Well caffeinated. What time did you get up this morning?
Not actually later than usual. Maybe 6:30. You know, take care of the pups, that kind of thing.
I love it.
Yeah,
I love it. And at 1 o'clock, you're gonna watch our Patriots.
Yeah,
you are. Are you going anywhere? Or are you gonna just have a little thing at your house?
No. I like to watch at home if I'm not there. We have like a nice kind of home theater set up. that is perfect for, large sporting event type thing. So yeah, no, I like to stay in the home base for this kind of stuff.
I love that. Mr. Bederow, I don't know if you know, because there has we know that there have been trolls online over the years that we have been on Twitter. And one of the trolls, it has come to my attention, I will not give credence to whom they are, but there was a question if they said that potentially that I see you next Tuesday, me, and you looked alike. I was wondering, like,
I don't
hit me with a compliment that's an insult in their mind.
don't think we have maternal and paternal lineage together, as far as I know. I mean, look, trolls are going to troll. It's really not worth. I mean, most of these people, they are what they are. These are miserable human beings. They live in attics and basements. They have a very high incel rate. And there's an illness, right? I mean, there's an illness if people live online attacking each other and discussing people's physical appearance all day and this and that. I mean, I wouldn't give it more than 5 seconds of thought. But I mean, there are worse things to be called than looking like you. So that's okay.
Thank you. And I just was wondering, like, if maybe someday I could go to the home theater, you know what I'm saying? And we could watch Patriots games together if we're family.
And we can watch Patriots games and we can bust out the family trees, and you never know. We could be long lost related. Yeah, no, I mean, these people are clowns. They are what they are.
Totally agree. And so this week, wild week. Want to start with, I know that you've already kind of talked about it with Mike over on the Young Jerks, but I always love to go into the civil situation for Karen and the appearance on Monday, I believe. Yeah. That was a lot more than I believed was going to happen at that hearing. The plaintiff attorney felt very ballsy to me, or not ballsy, but like it felt very like rehearsed. Like he might have been in his bathroom and he had done that speech 5 to 7 times. Like he was going up for a part. You know what I'm saying? Like it felt very theatrical. Like, babe, there's no who are you talking to? You talking to the judge? So, what was your overall arching thoughts of that hearing? Did you like the plaintiffs, their part, just from an attorney standpoint, and of course the South African attorney for Karen Reed, South African daddy, did a great job, and I really enjoy his accent. But other than that, what did you take overall from it?
So, I mean, I talked a lot about this with Peter Tragos, and I think that'll probably online sometime this week. But in a nutshell, they filed this lawsuit very early. Usually, you don't do that. I mean, and when they filed the lawsuit, it was before the second trial, and interestingly enough, it was with knowledge of what happened at the first trial, meaning what the evidence is that's kind of against them as plaintiffs. And when plaintiffs' attorneys file these kinds of suits, 99% of the time, it's on contingency, meaning you're telling the client, you don't pay unless we get recovery, other than perhaps some costs and expenses. So there's a lot of pressure at this point, and perhaps even a lot of regret. I mean, I'm speculating,
of course,
but they're going to be putting forth a ton of money on this lawsuit, and the fee structure will get very complicated in the event that all of these other people get dragged in and sued, and if they join that particular lawsuit, because it's going to increase the work for the plaintiff's attorneys, but we're not suing them. Is that covered, or do I need it? This is all very messy. So that's the first thing that kind of sticks out is they're stuck with this, and the likelihood of recovery for wrongful death and intentional infliction of emotional distress and all negligent infliction of emotional distress, all of these tort actions against Karen anyway, are all going to sink or fall, or rise or fall based on whether there's causation that she's the cause of any of the problems that they have. And
Right.
in English, that means if there's no car accident, there's no recovery, and we're done here, at least as it relates to her. The other problem they have is that certainly as it relates to some of these claims, is that the family members who obviously suffered harm. I mean, I understand it. A loved one dies, but the reality is that happens to everyone, right? I mean, everyone gets upset, and so
Yeah.
they draw restrictions everywhere about who can recover under a theory of civil liability for what you believe is the cause of a loved one's death. And it's a policy thing. Otherwise, you would have every single person who has a loved one die in some kind of negligent act, intentional act, literally overflowing the courts with claims that this affects me and I should recover. And the issue that's been raised certainly by the defense on a legal argument is that the plaintiffs here are not directly involved. They didn't witness, they didn't experience. Literally, it doesn't mean they didn't feel the pain and
Right.
suffering. So those are very serious issues as well. But I mean, we could break down a million different things about what happened. The argument for the motion to dismiss, I mean, the lawyer's grandstanding. That's what I mean. Clearly, I mean, you said practicing in the bathroom. He's zealously representing a client. I mean, it's what he's doing. I mean, it doesn't offend me per se. I mean, I thought the tone was a little much. I thought he made some very, we talked about this in the other interview that eventually will come out. I thought he made some tactical errors. Again, dragging in, he who shall not be named in some kind of conspiracy to do this. I thought that was a mistake. That's going to open a lot of doors that probably they don't want opened. It kind of supports what the defense is arguing with respect to these other, third parties who could get dragged into this. I also think, alleging that this was some kind of nefarious action where after this happened, that Karen basically lied to the child and created all this. Why would you go down that road? You're never going to prove that. I mean, and you have to understand a lot of what he was saying. It's like judges tell juries all the time what the lawyers say. It's not evidence. So, you can have a lawyer rant and rave all you want that she knows what she did. She knew this. And that's just all bluster. There's no, how are you proving that? And at the end of the day, the problem they're going to have, forget the bars. I mean, I wouldn't be shocked if the bars just throw a few dollars and that's what civil rights are and just whatever. And frankly, if I were the plaintiff, I'd take it because I think they're going to be, hemorrhaging money on this. And because I don't think from Karen, and when this is all said and done, so they might as well take what they can get. They're going to have to establish, even by a lower standard of proof, that, by a preponderance of the evidence, which is a low standard, it really just means 50% plus one, more likely than not in English, that she caused this. And what's interesting is that at the criminal trial, although the defense had no burden of proof, all you have to do is poke holes and say there's reasonable doubt, which is a whole nother world of, burdens of proof and evidentiary standards. But when you kind of take a step back and watch the evidence at the criminal trial, based upon all of the medical witnesses, based upon the engineering witnesses for both sides, you had the blue paint crowd over here and you had the professionals over here. You had all of the medical data over here. I mean, in essence, didn't they establish, meaning the defense team at the criminal trial, certainly by a preponderance, that it's more likely than not that there was not anything that she did which caused John O'Keefe's injuries and ultimately death and ultimately any liability. And you're going to see all those witnesses. They're going to all be back there. And what is the plaintiff going to do? The prosecution had unlimited resources and had a chance to come up with anyone. And they came up with a firm in which a guy basically put lipstick on the pig by using the state police experiment, added blue paint, bought some underwear and a baseball hat, and then relied on other data by a guy who apparently lied on his academic resume for years and said, trust us, bro, here we go, versus all of these other witnesses. So it's not going to get any better the second time around, even with the lesser burden of proof. So, in a nutshell, those are the issues. Now, the other thing on top of that, and the argument that Karen's people are making, this is why we should be allowed to bring in all of these third parties, because they are part and parcel of our defense that she didn't do this. And the plaintiff is going to have to establish that she caused the death. Now, how are they going to do that? They're going to they're going to say, but there's taillight pieces. That sounds great, again, in lawyer argument, but that's not how the sausage is made at a trial. You have to put in evidence, right?
Yeah.
So what's the evidence of the taillight? Proctor,
Yep.
Buchanan, Tully, these people, they're gonna testify anyway. Okay.
Yes.
So why not? The argument is allow them as a matter of judicial economy. As Michael Corleone said, let's settle all family business, right now. So that's going to be the argument. And, if there's further questions about it, that's just an overview, but there's a lot going on here.
Yes. No, that is an incredible overview. And there was a lot going on there. Now, what I was wondering, though, truly, is that when you're talking about the negligent infliction, the NIED claims, we get into a difference, and I wasn't able to explain it, to the wrongful death versus NIED. And I knew that there was a case that they ended up bringing it to the Sirico case. The Semino case of 1982, that they were able to do both, right? And that's a mass case, etc. that was brought up during the plaintiff's, whatever his argument. And the judge agreed that they were able to sue for both, or they were able to recover for both, rather, in that case. Now, but my only question is, I don't understand. In that case, it was like a small child who was hit by a drunk driver on the Mass Pike or something, and it was horrifying. It was like a 9-year-old kid. The parents were in the vehicle. I mean, for the love of Christmas, it was a lot happening in that case. And the child tragically passes away. Now, I know that you're saying that they filed it early, right? They filed it very early. They got on this, meaning the O'Keefe family. But when you're looking at how the connection needs to be close, and you're looking at not just where you were, you have to be close in proximity, but there also has to be a proof of either medical records, or you have to have a rash of unknown origin, or you have to have something that has affected you that is more than just grief, because we, like you were saying, Mr. Bederow, all have grief at the loss of our loved ones. And there has to be that line in the sand that shows that this goes from, a normal passing to a emotional, a wrongful death. I mean, not a wrongful death, the negligent infliction of emotional distress claim. So for me, this is opening up, and tell me if I'm wrong, the medical records and all the things for every person that is asking, that is looking for a recovery here. So every person, that would open up your psychiatric records, that would open up your medical records, that would open up everything since the death of Officer John O'Keefe. Is that correct?
I mean, that's 3 layers too far for me.
Oh.
No, I mean,
Sorry.
No, I think the point is simpler. And I think this was a tactical error
Oh,
the plaintiff made in the argument, because when you're going to cite a case and they're arguing, there's no restriction on, that somebody has to be present or can whatever. When you heard Karen's lawyer get up and say, yeah, but what he didn't tell you was in that case, as you said, the person who suffered the emotional harm was in the accident, right? They literally experienced the trauma in real time. They saw their child or whatever the facts were in that horrible state.
yeah.
And so that's different. Okay.
Mhm.
So as far as, mental health records of the plaintiffs, whether that be, Paul O'Keefe, John O'Keefe's parents, the children, I mean, that's kind of a secondary issue. I mean, they have a legal hurdle to get over, which is, they weren't there. And again, that's not a shot at them. It's a legal principle that applies to all cases. I mean, I remember there was discussion, from the Twitter lawyers weeks and weeks ago when the defense filed their papers about how outrageous it was to say that these people didn't suffer pain and suffering. And these people who say that, they're just morons. That's not what they're saying. Anybody, of course, understands that John O'Keefe's parents, of course, they suffered from this and other things that have been horrible that none of us have ever experienced. But as a legal principle, you can't necessarily sue because something happened to your loved one. And the argument is, they're alleging that there was a death here around 12:30 in the morning, give or take. Okay. And they learned 7 hours later, right? They weren't there. It's just, these are facts which are not helpful to them in terms of perhaps surviving a motion to dismiss on certain of these claims. And it's just a straight policy argument. Now, is it kind of mushy? Can a judge do this or do that? Potentially. I mean, these things are very case specific, but if people were with him when this allegedly happened, and I say allegedly happened on top of the fact, we're just talking in the context of a motion to dismiss, right? So the judge has to assume that the pleadings of the plaintiff are all like true for purposes of the motion. And what the defense is saying, even the way they pled it, even if this is true, these people can't be plaintiffs because they weren't percipient, they weren't experiencing it in real time. I mean, there's like hurdle after hurdle here. And even if the judge denies the motion to dismiss, they still are going to have to establish at a trial by a preponderance of the evidence that Karen is responsible for this. And it's going to have to be better than a plaintiff's lawyer saying she knew what she did and she lied. I mean, that sounds great when you rant and rave like that, but trials are based on evidence. You need evidence, and lawyer argument is not evidence. And the evidence that you've seen so far, the engineers, every medical witness, the problems with the state police, the problems with Michael Proctor, the absurdity of finding taillight pieces week after week, day after day, and blah, 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 blah. You could go on. How the hell are they establishing, even by the low standard of proof, that it's more likely than not that it happened the way we allege? And again, this suit was filed before the second trial. Okay. They didn't see.
And they didn't know. Yeah.
Aperture stuff. That's the best they had. They didn't see how the ARCA guys were going to hold up the second trial. They didn't see La Posada, who was a spectacular witness, and that the medical examiner was going to help, the defense in essence. But what's interesting to me is they did know generally that Proctor was a disgrace, that Buchanan really lacked credibility on some of the things that he was saying in the inverted video and all of that nonsense. They knew what the ARCA guys were going to say. So what I'm trying to understand is why they brought the claim at that point in time. And now they're stuck. Right. So, and the idea that Karen and her army of lawyers are going to give them an out is unlikely. The bar is a different story.
Yes.
They're stuck with this. And it's almost, when I say stuck with it, I mean financially stuck. It's almost certain that the plaintiffs are not paying for anything other than potentially, you know, again, some fees and expenses, unless there is a recovery, and it just seems unlikely. Can I ask for a 2-minute break to get more coffee?
Yes,
Be
you
right
can.
back.
We're gonna do a little pee break and get some coffee for goodness sake. Boo doo 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 doo. Good morning. Mr. Bederow's here. If you don't know, I was late. I was late for a very important date. Blame technology, my loveys. It was not me. I would never be late for the one and only Mr. Bederow. Why am I talking like this? I think I'm going to go grab just a little bit of tea. I don't have the pot on right now. Oh, lordy, lordy, just kidding. Hey, let's watch something. Want to watch something with me? What do we got for media? Oh, please. I gotta have a little note. Oh, we can watch this.
But what happens when I spread my load out, when I lay on my bed like this?
Oh, you know exactly what happens. Judd. I'm gonna play this for 1 second, loveys, and then I'll be right back.
Nurse Kim, what the fuck are we talking about here? This is the problem with this whole case, my opinion. We got a big problem with that. Your man JFK got a problem with that. That's your opinion. I get all that. This is the TV, court TV. We got to keep it real nice. Okay, I get all that. But I won't sell my soul. Whether I'm on court TV, whether I'm on Shade 45, whether I'm in the car, whether I'm at the bar, or whether you see me walking down the fucking street, I ain't selling my soul.
Oh, I'm sorry. Where am I? Oh. We're having, oh gosh, Lord help us today. Lord help us. Hello. Oh, now you can't see me.
I'm back.
You're back. How's your coffee?
It's superb.
How do you like your coffee? We don't talk about this.
Just a teeny weeny bit of skim milk. So mostly dark, and one stevia in the raw.
Oh.
I grind my own beans, very fresh always, and or sometimes if it's not a whole pot of espresso, we have an espresso machine.
Oh. I like my tea just with skim milk.
Just a tad.
Just a tad.
Just a tad.
Isn't that weird?
Yeah, no whole milk.
No.
No.
All right, sorry, I digress.
Yeah.
Thank you for returning. I started doing like ASMR, and then I felt uncomfortable, so I was like, let me grab a drink. Okay, so I wanted to go back into let's turn back the hands of time, because you mentioned it, Dr. Laposado, who was a trial 2 just superstar, if you ask me. One of the best witnesses I've ever seen on the stand. Incredible. She rattled Hank Brennan, in my opinion, like nobody else. It was like a school teacher. There was a vibe that I got from her of like taking absolutely no shit. She said bullshit on the stand in her tiny little lady voice.
Let's also understand the dynamic there.
Oh.
He had used her as a witness in private practice,
Mm-hmm.
and had presumably prepped her to defend against the very allegations that he later used to try to discredit her. Now, you want to get into conflicts and all that kind of stuff, that's a whole nother conversation. But he did appear uncomfortable because, you know, he's coming after someone that he presumably had spoken to in a privileged and confidential nature about her alleged, credibility issues, if that's even the word, about the Rhode Island fire that he tried to poke her with. And it was clear to me that her demeanor was, how dare you, basically.
Literally.
I mean, she clearly has no use for him. And I mean, so there was a very strange dynamic, I thought, going on there. And that had nothing to do with the substance. Now, in the substance, I mean, she just rolled him, obviously, because the science is what the science is. And he was flailing around like a fish out of water. I mean, it is what it is. Science is science.
Yes. Now, So this might be nuanced, and tell me, Kim, you're too far in the weeds, because you know how I get sometimes. But Dr. LaPosada was and I said this in like my review of this, was that of this week's hearing, that, you know, it was very interesting to me because everything she said on that stand specifically was in favor of Officer John O'Keefe when he had the head strike, okay, however it happened, that it was within minutes that unfortunately Officer John O'Keefe would have been rendered unconscious. Then he would have lost his motor skills, his ADLs, and then at the herniation of his brainstem, which she says would have happened in rapid succession, that he was not alive when he was found. Okay. That was like, if you go back to the testimony, you would see that no, it all happened when at whatever time the injury occurred, that is when Officer John O'Keefe succumbed to his injuries. It was not upon the time of death that is indicated at the hospital, right? At Good Samaritan. And would that in theory make a huge difference for your pain and suffering and for your ability to recover if there was, I mean, granted, I know that it is time of death. It's on a death certificate, etc. But you have a medical physician saying that 12 or whatever time would have actually been the time of death.
So there's a lot more to unpack there. And I think it's actually worse for the plaintiff than you suggested, because what I believe the testimony was, and if I'm wrong, so be it, but I don't think I am, but if I am, someone will say,
yeah,
is that he was immediately incapacitated.
Oh, yes.
If this had happened, which that certainly affects pain and suffering. And like you said, time of death. Yeah. And again, but we're jumping the gun. That's assuming these people can even be plaintiffs for some kind of this recovery. That's
right.
You can even establish causation. And even beyond that, you're assuming if you can do any of that, how much is there for pain and suffering if something happens like that, which is always less for somebody who were to die in a tortured agony, all of that. I hate that.
I know.
Layers to this, but there are layers to this. But the other problem, and this goes to the whole causation thing again, and if there's no causation, none of this matters, right?
Right.
And if the man was incapacitated immediately upon impact, then how is his phone being manually manipulated after? You could go on and on.
God, that's why I love you.
The fundamental problems with this case. And, when the plaintiffs filed the suit, they don't know that. And when the plaintiffs filed the suit, I haven't looked at the complaint in months and frankly don't care to unless somebody shares it. But I think their timeline is going off, the Jen McCabe original timeline from the first trial. It's just parroting that. So it's just all of this is a complete mess.
Yes, absolutely. And the proximity though, so causation 110%. Duh, Kim, go back to basics.
That's going to wipe out causation right there. If the phone is being used with Face ID, and my recollection of the trial testimony is, manually typing and checking messages. Incapacitated and dead people don't use iPhones after they're incapacitated and dead. Full stop.
Touche. Checkmate. There you go. That 100% has clicked in my brain, and I don't know why it was taking me a minute to kind of get there, but you've completely explained that to me. And I will say that I wanted to get into one other area, and it is if the reason that the plaintiffs are able to say, or how they were able to file this, was saying that they were at the hospital. They were at Good Samaritan Hospital, right? They were at Good Samaritan. And this is where the plaintiff lawyer is saying, ba-ba-da-beep-ba-ba. We were there. Officer John O'Keefe is pronounced at 7:50. We are immediately taken into the back to see him. And that is allegedly their, connection. But
Okay.
how does that work? Because all of us, if I'm at a hospital and I go to see I go, or I'm called, it's whatever. There's a terrible car accident. Let's just say an actual car accident. There's a terrible car accident. Or I'm not in the car though. My loved one is transported to the hospital. I could be following them for Christmas sake. Somebody's working on them. They're working. You're in a waiting room, and then unfortunately, God forbid, a time of death is called. You going to the back room, you brought yourself there. You weren't part of that accident unless you were in the accident with them, right? I'm in the car with you. I'm in a different ambulance than you, right? And or whatever, or I don't need to go. I'm driving the car. Somehow the car is still fine. This is not a great example, Kim. Shut the frig up. But you know what I'm saying? Like, if you bring yourself to a hospital, like the O'Keefes did, right? Paul, they drove themselves in a blizzard, right? And Kerry, Robert, everybody's going, you're going to the hospital. What the fuck? How, what does that, how are you there for when you're saying the emotional impact? Like how, when there was a car accident hours before?
I mean, look, each case is fact specific and you have to go by that. But in this particular case, it's very simple. Again, factually, it's emotionally distressing, but factually, in terms of assigning civil liability, you find out that there's a terrible accident or intentional act, whichever the case may be, where something happened to your loved one 6 or 7 hours later. Most people are going to rush to the hospital. And obviously, if there's a chance to see the victim, whether it be living or not, you do that. That does not translate to a legal theory of recovery. I mean, the reality is, if God forbid something happened to one of your family members today, and you learn 6 hours later, and they may be passed or on the precipice of whatever, and you rush to the hospital and you have a chance to see your loved one, and then you later learn that this was a horrific drunk driving, and you want to sue the person who did it, you're not going to have standing to do that. I mean, again, that's not a shot at you. It's not a disrespectful thing.
Right.
It's a way to keep courts from being overclogged with 10 million lawsuits that just can't happen. It's a lot of the reason why prosecutors have so much immunity, civil immunity, which can be very difficult, because every either acquitted defendant or wrongfully accused, or so they say, wrongfully accused person says, I'm going to sue them all. And you just, you can't allow that. And there are so many other problems with this case. One of the things, for example, that the plaintiffs have been saying is, well, she's always talking and, no more, there's no more Fifth Amendment right. Really? Yeah. Really? There's an investigation going on, allegedly, involving alleged witness intimidation of 1 or 2 people, right?
Yeah.
Well, guess what? If that's the case, Fifth Amendment. So again, things are happening.
Yeah.
Are not necessarily good for what the plaintiffs are trying to do.
Yeah. Oh gosh. Yeah, that's not good. And Mr. Bederow, can you just explain to me, because I'd never heard this, and again, I'm not a Twitter lawyer, nor do I play one on TV. I'm just a Kimmy. And I had never heard, or I of course know about vulnerable populations, right? Like I know about children and elderly, and of course I have, as a registered nurse, there are social determinants of health that are affecting our patients, etc. But I thought it was kind of an interesting route for the plaintiff's lawyer to go, to be saying that he not only has a vulnerable client in the niece of Officer John O'Keefe, but also her parents. I mean, her parents, his parents. So I think that he was saying, or correct me if I'm wrong, that that Mrs. O'Keefe would be a vulnerable population because of not only her age, but also the loss that she has experienced in her life. But those, unfortunately, are pre-existing conditions. No child, like the niece of Officer John O'Keefe, niece and nephew, should ever have to experience the loss that those kids have in their life. None. It is astounding who they have lost. And I hope and pray that they have beautiful lives and are able to go forward and have wonderful like families of their own, and God bless them. But that is not cause from January 29th, 2022, and did not have the direct by law impact that would make them that vulnerable population, in my opinion. Is that correct or is it incorrect?
I mean, look, they're arguing basically, this concept of, the so-called eggshell plaintiff. They're already injured, and how do we bring that in? And does that contribute to this? And the defense says the problem's pre-existing, all that kind of stuff. But that aside, the problem that they're going to have is those arguments. I mean, that's more for the public or more for the heartstrings. I mean, obviously the heartstrings are strong for the two children.
Absolutely.
And they're specifically trying to play that up with the daughter in particular, who had the misfortune of being home when, the three women were running around the next day trying to figure out what happened. But the problem they're going to have is, why would you argue that Karen, without evidence, again, no credible evidence anyway, is literally lying intentionally to the child to cover up this nefarious crime that she committed? I mean, it's a bridge too far. It's an unnecessary burden. I don't think it's credible. It's not supported by evidence. And you can't win just based on emotion. I mean, it helps. Obviously, you want to pull the heartstrings, and juries tend to throw more money when they're pissed off and feel terrible. But there's still this nasty little thing called evidence that you need, and there isn't going to be some smoking gun here. I mean, again, this isn't going to be like you heard before Karen's second trial, where a lot of the Twitter lawyers and their favorite YouTube people who live in the attic and other places tell them something big's coming, the science, the data, and you cultists are going to do this. They had their shot, right? I mean, it's not like Brennan held back, right?
No.
He emptied the tank, all right? He fired the gun, and the gun was blank, okay? It was empty. There's nothing there. There's no proof. Now, it's a higher burden of proof. That's true. This is a much lower standard.
Yes.
But when the plaintiffs filed this suit, they had to be thinking, the lawyers anyway, if she gets convicted, the civil case is over. There's this other nasty concept in the law called res judicata, that if an issue is determined, it need not be relitigated. And if she's convicted of either murder or manslaughter beyond a reasonable doubt, then the causation issue is clearly established by a preponderance. I mean, this
clear.
Is like third grade level rational common sense analysis.
Right.
But the problem is they didn't do it. But not only that, in a legal sense, Karen was acquitted because there was reasonable doubt. But in a practical sense, for people who watch this process with an open mind, they kind of did prove by a preponderance of the evidence and more that there was no impact based upon the credible evidence in support, medical evidence, engineering evidence, evidence that the state police are probably corrupt with Proctor and this and that. The evidence appears to be overwhelming that there is clearly not a preponderance of the evidence that would support that Karen Reed's conduct caused all of this to John O'Keefe and by extension to the plaintiffs. It's a loser.
Yeah. Yeah. Thoughts on how long this will, because I know that this is long and that it wouldn't be 27, 20,
They bring in, if the judge allows them, to bring in the, Jen McCabe, her husband, Brian Albert, his wife, Proctor, Buchanan, Tully, and Higgins. That's going to delay months and months, several months. The trial by extension becomes, what's like an old-fashioned New York mafia trial where, we need extra tables in the courtroom and all that kind of thing. This is going to go on for a long time. And again, they're not, the more, well, this is a conspiracy between Karen and Turtle Boy and this and that. And then you have, ostensibly an alleged criminal investigation going on of them. Well, guess what? Again, the Fifth Amendment comes into play. You could be looking at another stay. I mean, is this helping?
Yeah.
The answer is no.
No.
So this is going to go on for either way, a long, long time. There's no way this case, even with or without these third parties, is going to get tried anytime soon. And either way, we're being told they're going to sue these people, which is going to just cause more delay anyway, because they're all going to have to be deposed in connection with this case anyway. They're all going to have to get this is going to be, this is a grade A shit show that will take forever.
Okay. And that was just from one hearing. Thank you so much for breaking all that down for me, because I was literally like, what are we doing right now? But it was, there was enough information that we got out of that hearing for us to say exactly kind of what is being set up here. And like you said, it's so layered, Mr. Bederow, like that it just, you're asking for, yeah.
The problem is this. The plaintiffs filed a lawsuit as a cookie cutter garden variety civil lawsuit that happens every day, and they're boring, and it's just a wrongful death, IIED claim, and you drunk drove, killed our relative, and it caused us harm. That's the claim in 20 seconds. The problem is this is so much more layered. There's so much nuance. There's so much more going on here. There are so many third parties that are relevant to this. There is the whole state police corruption thing. You could go on and on. And the reality is what the defense is saying, this is not a cookie cutter, open and shut wrongful death case. This is an absolute nuanced fiasco, and we're going to fight it to the death in that way. And we have a right to do that, and they're going to do it. And it's either going to be joining these third parties or having, simultaneous parallel litigation go on at the same time. And again, it's all going to cause havoc in criminal proceedings. With this ongoing investigation that they claim is happening, I think people that matters. That's the civil case. It also, look, I'm not going to lie to you, it impacts existing criminal cases. The alleged victims who have been witness intimidated in a case in which Karen was acquitted probably twice are now going to be sued for conspiring to violate her civil rights. That's not good for the prosecution in existing criminal cases. And that's all going to be fair game and going to be vigorously examined and approached. And when they get deposed in the civil case, that's all going to come out. So this is, there's all kinds of orbiting satellites going around the same sun in this, and it's going to just cause a lot of delay and complications. This is not some simple wrongful death suit like the plaintiffs were hoping for, and hoping they were going to get a conviction at a second criminal trial, and that this would be dotting I's, crossing T's, and a path to a couple $1 million. It's not going to be the case.
Yes, I totally agree. Now, and there's no way that odds that they were to say we're going to drop it. Zero.
That's complicated.
Okay. I was just wondering.
You have all kinds of things, and I'm not suggesting this is the case. We're talking generally.
Yeah.
Could a plaintiff's attorney say, look, I want out of this? The question is why? There are ethics components to this. You can't just bail because you realize after you filed a lawsuit, you did these things and you said, oh Christ, we're not going to get anything, and I'm hemorrhaging money, and oh my God, this is never. I mean, so you can't just say see you later to the plaintiffs. That would be, I mean, you can't, abandon ship like that. Does it color you to say what can we extract from the bars, get whatever we can? The plaintiffs are never going to want to drop it. I mean, they have, in essence, free lawyers, right? I mean, that's how plaintiffs lawyers get cases.
Yes.
The attraction for the plaintiff is we don't have to pay. And the attraction for the lawyer is, well, I'm going to get a third of $10 million. I like that, so there's a take there. So, but the plaintiffs, look, they believe that she did this. I think that's unfortunate. I think they've been misled. I think they've been subjected to all kinds of influence that you wish they weren't. But the reality is, I don't doubt that they believe. I mean, I see this all the time in murder victims' families or people who die. I mean, certain ones come to mind where, I was involved in endless appellate and wrongful conviction litigation for 12 years. And this family shows up for any court appearance and they're sincere. I mean, I think they're wrong, but they believe it. They were very nice people. I mean, I felt terrible for them, but they were sold a bill of goods, in this case by the Brooklyn DA's office, and they believe it. I mean, and it is what it is. I mean, so I don't doubt that the O'Keefes believe it. I just think they're wrong and misled. But so why would they want to drop it unless they're presented with something that wouldn't lead to it? But I think, if you read the tea leaves here, their path to recovery and so-called accountability for who they believe is an acquitted, nevertheless guilty killer, I think they're wrong. And I mean, even by the lower standard, they're just not going to get what they want here. This is destined to fail for the same reasons the criminal case failed, even with the lesser burden of proof.
Wow. Well, thank you so much for that, Mr. Bederow, because I always have little rando questions. You know how I get a little minutiaed and I get like into the weeds sometimes, but you are the one to get me out of those weeds, and I appreciate you. Can we move on to whatever we can discuss about the Turtle Boy case and what happened on Wednesday?
Sure.
Yeah.
What's public?
What's
is
public?
Right.
How about Mr. Bederow, Mr. Bradel, and Judge Dulan? I'm obsessed. I can't. When he says your name, I giggle like a schoolgirl. I'm obsessed. Do you love him? Like, for judges, do you love him?
Well, look, lawyers only ask for certain thing with judges, right?
Yes.
You ask to be treated with respect. You ask for good judicious temperament, if you will.
Yes.
You ask for intelligence, and you ask for fairness. Okay. On that scorecard, I think Judge Dulan is 4 out of 4, right? I mean, I think he does all of that. And what I don't do is judge a judge by, did you rule for me or against me or whatever. And what I don't do is do what Twitter lawyers do on both sides, by the way, right? I don't sit here and say, well, because he didn't dismiss the case the other day and scream and yell and throw a gavel off Cosgrove's head and say, dare this go forward, and how dare, we adjourn this case to December, and say, oh my God, well that, this is outrageous because the case is scheduled for December. That's what judges do. Okay. That's what judges do all the time in all kinds of places. And, Massachusetts is very unique. They don't have a speedy trial statute. They don't have the kind of schedule orders that I'm used to. So
yes.
So it's a little different, but I don't leave court the other day and say, oh my God, I'm so pissed off that this is adjourned to December, or why didn't he do this? The reality is this, okay? What happened the other day is he agreed to kick off or accept the withdrawal of 2 remaining lawyers on a case. And we now have an indictment that, I mean, the word I used was stateless. And I mean that in the sense it's just screaming for attention and there's no one to give it attention. It has no rights. It's just this, dying nothing case. I mean,
Yes.
it is literally without a prosecutor. I mean, this is insanity. Okay. And what did he do? He said, we need, and Cosgrove correctly says, don't ask me. I'm out. I'm not speaking for the DA's office, which is correct. He didn't do anything wrong.
Right.
He did the correct ethical thing. He's being sued for intentionally violating the alleged victim's rights, which is
God.
the fact that suit exists is just insanity. But whatever, that's neither here nor there. The bottom line is he did the right thing. And then when the judge says, okay, fine, then you need to have the DA assign somebody else. And we have to stand up and say, well, they kind of can't do that because she's threatening to sue them too. I mean,
And you did. Yeah.
I did. And what did the judge say? Okay, well, whether it's the attorney general, get somebody here to tell me what's going on in 30 days. Okay, that's a correct ruling. He didn't. So, whatever the question you asked 10 minutes ago was, what do you think of him? He checks the boxes for what you just want a judge to do. That's all. I mean, so it's not like I love this guy, I hate this guy. You just want consistency. You want to be able to argue what you can, which he allows. He lets the other side say what they want to say.
Mm-hmm.
Does it in an even-tempered manner.
Always.
And treats everyone with respect, and then makes rulings, some of which you may agree with or some you don't. That's all lawyers can ask for in a judge.
And Mr. Bederow, if it's okay to ask, are we able to, okay, so in the event that like whoever has to come, somebody needs to represent the Commonwealth regarding it on in 30 days, right? Somebody has to get to court to do the count that, or the case rather, that Cosgrove withdrew on.
Good luck.
Good luck. Okay. Thank you. That's what okay. All right. Got it.
Look, you're not a lawyer, obviously, but put yourself as a credible, respectable lawyer with everything that's going on. Are you doing that?
No.
I mean, look, I'm not going to get into the merits of the case and the credibility of witnesses. It's all been said before. It speaks for itself, both before in the last couple of years and even in the recent past, online, other things. But on top of all those problems, are you coming into a case where you're going to get sued by alleged witnesses in the case? The DA is going to get sued for your conduct. The lead detective on the case is going to get sued. What serious, credible lawyer is, without even getting into all the other problems with the case, and there are many, would take that? And the reality is this: there's other problems here. I mean, we already have a motion to recuse, Mello on the other case, the existing case, the 2020 case. And in light of the developments that have gone on with the lawsuits and what we all recognize, as Cosgrove admits, as we allege, and the judge, there is clearly a conflict between the interests of the government prosecuting, which wants the witnesses and needs the witnesses to be credible, right? We obviously believe a lot of these witnesses are not credible. And then if you have a prosecutor on any of these cases who has his own interests, which are contrary to the government, in the sense, if he's being falsely accused of misconduct by a witness that he ought to be defending their credibility, it's in his own interest to discredit the witness because he's being sued for stuff that he didn't do. So the point is this: if that kind of witness is involved in other cases and is a potential witness in those cases and could be examined, then how can that prosecutor be involved in those
any.
cases, or as the case may be, open investigations, which may involve that person. So this is there's a lot more potentially at stake here than just the 2024 case being stateless.
Wow.
Look, all of this is I mean, no one's ever seen anything like this. I mean,
No.
I've been doing this almost 30 years. I've never seen anything like these kind of tactics by witnesses, and in terms of just going after everyone and all of that kind of stuff. But it is what it is. I mean, it's a free country. You can do what you want. But when you conflict prosecutors, it matters. And, we intend to fully point that out and argue that and kick them off if there's conflicts. And it is what it is. I mean, we didn't ask for this. We just go where they send us. And this is the playing field that we're in. So, if we have to play in that sandbox, then, we'll bring the shovel and dig our way out.
Yeah. It sometimes feels like a shit box that it is instead of a sandbox. Okay. But the far reaching implications and the incest, and it's not like, I don't mean like incestual, but like how everything is so interwoven and connected, and the web is so intricate, right? In the cases that is astounding to me. And when you make the connections, or when you're doing a freaking whiteboard of like how this is connected to this, and how the conflicts, in my opinion, are aplenty.
Rant on us with the string board.
Oh my God.
Don't do that. Don't go down that rabbit hole.
I love the string. I love that chart. I love it. I absolutely love it. When I saw him do that, I mean, that's very, very true detective of him.
Yeah, I saw this the other day. I don't even know if it's real or people are playing, but there are allegedly future Supreme Court justices that are on that chart.
Oh, I didn't see that. Oh my.
Yeah, anyway,
didn't see that one.
Anyway, what
Yeah.
Lunacy. Go ahead.
Well,
Sorry.
Brandy Churchwell, for cases like, see, here's the thing is that I have, Mr. Bederow, is a weird brain. Okay. And I go off on tangents. So what for me is the best thing to do is like Brandy was able to compile the charts for Karen Reed trial 1 and 2 that like saved. And this was for me to explain it to others, because I'd be on rants. You know me, I'm going like, bah, 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 and I'm talking about all the players. And then they'd be like, Kim, can you please tell me who the fuck is it? Who are you talking about? I'm so confused. And so for Brandy to be able to like compile all of those and how like the family trees of everything, I would say to like loveys, I'd be like, here, loveys, look at this. And now listen to my tales of whatever I was going into. Because it's just very important to me to have a visual representation. I am a very visual learner, and then I can talk I can talk everything about it, because as long as I can see it and know it, set it and forget it, and let's go. So from Wednesday back to you, and back to the hearing, it was so short. I was like, oh, you know what I mean? Because I was like thinking in my brain, I was ready, Mr. Bederow. In my head, this is what I was thinking. I had made up my own dramatic gay ending. And I was like, oh, yes, Kimberly. I was like, get your popcorn ready, because we are dismissing something.
No.
And it was not correct, because it wasn't supposed to, because Judge Dulan made the right call.
Well, he made the right call. But I mean, people, again, cases work in a certain way.
Yeah.
And we filed a, very complex, complicated motion, and they have a right to respond in writing. So, I mean, this was never going to be decided based upon, I mean, look, I think it's pretty damn compelling, but that's not the point. The judge has a right, and the DA, even these people have rights to respond, and whatever that may be, and put that in front of a judge, and then have argument in front of a judge. So this was never going to be a hearing where there's going to be screaming and yelling and arguing this and that. And then once it was clear that there was a motion for the prosecutor to withdraw because of a glaring conflict of interest, I mean, no one was going to dispute that. I mean,
No.
clearly he's being sued by this person. I mean, he can't call her as a witness on behalf of the Commonwealth while we're arguing she's incredibly not credible. And guess what? He's going to agree with us.
Yeah.
I mean, the reality is it's in his interest to say, you're full of shit.
Yeah.
You're suing me on stuff I didn't do. And, you know, whether we sit here and laugh at the idea that he intentionally tried to cause a witness emotional harm, the reality is, I mean, you know, you don't see that every day, right? I mean, that's nothing you see. So that was going to be granted right away. But, you know, the things that will happen going forward, as I said, that conflict between witness and prosecutor doesn't exist in a vacuum. Okay. It doesn't exist within the four corners of a 2024 indictment. Okay. It absolutely has diffused and pre-exists in 2023 and in this alleged current investigation that's going on right now. And if that conflict is put out there and shown to a court, then guess what? There's no difference just because of one indictment. If there's a conflict that's going to anywhere that witness and prosecutor may intertwine, where he has to examine her on the stand, or any other witness where there may be an alleged conflict, or regarding subject matter involving a detective who also, frankly, you know, ought to recuse himself from all this, being sued, but that's another story. This conflict is going to go a lot deeper than just what happened last week.
Noted. Over under on Hank Brennan taking the case. Sorry. I digress.
I mean, look, first of all, let's analyze the legal problem here. Okay. Who's hiring him? The DA has a conflict. Okay. Michael Marquis's office is going to be sued by the same person who has already sued Cosgrove and Tully. Okay. And this is what I was trying to explain to the judge. He has a conflict. He can't find anyone, whether he wants, you know, a fixer that, you know, he views Brennan as a fixer or someone else. He's conflicted. Okay. Is he doing this to help himself and his office, or is this for the integrity of the case? Is this person working for him to help him in his office, or is it to get justice for the indictment? Okay. The conflicts that surround this because of a witness suing Cosgrove, suing Tully, and threatening to sue Morrissey in his office are suffocating. They're everywhere. Okay. The conflicts are everywhere with this.
Yes.
DA can't appoint him. Now, who in their right mind would appoint this guy?
Right.
Okay. Who's going to do this? The Attorney General, who, if you read the publicly filed motion, was begged to take this over and over and said, no, we're not doing this.
Yeah.
Publicly filed. Those exhibits are not under a protective order because they were released in a FOIA request, and so they're publicly available. They asked again and again and again for the Attorney General to do something, and they said again and again, no.
No. Yeah. The answer was no, resoundingly.
And this was in 2023.
Yeah.
Now, knowing what you know now, Karen Reed has been acquitted probably twice. The witness has sued is about to sue the DA, has sued the prosecutor, sued the lead detective of the state police. The state police have corruption involved with Proctor, possibly others. Now the Attorney General is going to come in and say, sign me up.
Yeah, not a chance. You're absolutely right. Now, did I see was there a filing to unimpound the mega motion?
That's all because of the protective orders that are in place. The filings on this case, if they reference certain materials, need to have two versions, an unredacted version and a redacted version. But when you file something in the way this works, again, Massachusetts is really unique.
Yeah.
Still feeling my way through this. It's, you know, not my thing. You still have to file something to basically move to impound the unredacted version to keep it from public view. It's all
Oh,
nothing.
I'm sorry, Mr. Bederow, because I was so excited. I was like, oh my gosh, are we trying to unimpound town the redacted
We have. I
mega
mean, we
motion?
try, at least at
Yeah.
this point in time. It's really a protective order, as opposed to, this is all semantics. The bottom line is it's
Yeah.
shielded from public view. I mean, this will be revisited in the future, but our point is very simple. It's a matter of public interest. The stuff that's impounded relates to people who you see go on TV, go on Twitter, post videos, do this. I mean, frankly, impounded messages in our motion were publicly released on Twitter by a witness last week to prove a point about another witness. I mean, that's beyond that. Other messages were released in a Freedom of Information response. So I don't know why anything would be impounded or under a protective order if the other half of the DA's office is releasing it to the public. But again, we go by the rules that are set by the court. And if the answer is, for now anyway, that this has to be redacted, then we redact. And, it'll be revisited. At some point, this all comes out. I mean, anything that has a black line through it in these motions is going to come out at a trial. And frankly, some of it will blow your mind, both as it relates to, evidence in this, or, things you may or may not have thought about, even more related to Karen's case. It'll blow your mind. But for now, it is what it is. You got to follow the rules of the court, and that's what the lawyers do.
Yes, you do. And you do it so well. There is so when is it next? December? No, not December. Is it November 21st?
No, the court date, I think, is December 5th.
December 5th. Yes. Okay.
Ought to be oral argument on the motions that are filed, which are basically to dismiss and to toss Mello, which is semantics at this point. But nevertheless, there are reasons that we need to do that before taking other action with respect to his role in this. They'll file a response in October, late October, to the motions that we filed. It's entirely reasonable to believe that there will be other motions filed before then, which again will raise other conflicts of interest. And then we'll see where we are.
Wow. Wow. Okay. I love that. And I know that there was a lot of people that have specific feelings kind of about Judge Dulan, but I'm going to tell you this: after watching Karen's case and after seeing Judge Cannoni for the extended amount of time that I have, I can see I feel as though his jurors' prudence and his everything is just, he's very, very even tempered, and and just like, he just seems like a gem to me.
So let me just be very clear. And again, this is coming from a lawyer who has been doing this longer than I'd like to say, but 27 years or whatever it is, who deals with what we call Supreme Court judges in New York every day, every now and then federal judges, and yes, some judges in Massachusetts. You're getting analysis from people who are not in the arena or are Twitter lawyers or whatever. This affects us, okay? We're litigants, okay? There's no problem with Judge Dulan, okay? There's no problem with matters being adjourned. It is what it is. This is how criminal cases that are complicated work. They get a right to answer a motion, okay? As a lot of the people like to laugh and complain on Twitter, the motion's long. They're allowed to respond, okay? They're allowed to ask for time. They get it. It gets adjourned for this. There's no prosecutor on this other case. It doesn't get dismissed that day.
Right.
As there's no problem with the judge. There's no conspiracy. Do I agree with everything that he's done? No. Do I think that, again, there ought to be protective orders about information that's being shielded from the public? No. But you know what? Judges rule. You can agree or disagree. Sometimes you agree. When they toss Mello off the case that we argued, back in a crayon letter in 2024, but he granted it. Okay. I agree with that. I don't agree with other things. So what?
Yeah.
So, you know, so if the people that are involved in this can tell you there's no problem here, there's no problem here. Judges do things that you agree with or don't agree with. There's no story here. Is December 5th a long time? It is. But you know what? They're going to respond to this. There could be other filings. We may want to respond to theirs, a reply to their response. This is all the way complicated litigation works. And if we're not complaining and we're not upset
Then
about
we
it,
need to stop. Yeah.
you don't need to worry about it.
Yeah. And also, correct me if I'm wrong, but I believe he said the Walsh trial was going to be coming. And he said, so we'll be out of session. That's why at the end of October. So I said, oh, you know what I mean? I was like, clearly he needed to accommodate for their trial schedule. So makes sense to me.
Again, do you want to see this move quicker? Sure. But there's a lot going on here. And the time, again, I don't want to share strategy and whatever. And people know from watching 10-minute hearings and going on Twitter and, providing analysis and whatever. But there are things that go on, behind the curtain that time can be to our advantage too.
Mm.
So you just, with respectfully, I mean, I'm not trying to criticize anyone, but
of course,
you don't know what we're thinking, what we're doing, and what we like and don't like. It's okay. And people can analyze and are entitled to their armchair opinion. That's fine. And the lawyers can be too passive. You can be too this, to that. That's okay. But there's a method to the madness. Okay. Yeah. There's we're not new at this. We Tim and I have been doing this a long time.
Woo! A silver fox and my dapper dudes. Okay. So, and listen, and we've been Better Call Bederow for almost 2 years. Okay, people. So we know better. And if there was a problem or if there was something that we would, it would be known, and that there's not, and that this is the way it goes. And if nothing else, Mr. Bederow, you are so fair about everything. And like how you always say, like, our First Amendment applies to people that we like, right, and that we are supporting, and it also applies to those who say the exact opposite and that are against every single thing that we believe, because we have to fight for them as much as we fight for Aiden. So at the end of the day, that is where I always appreciate you reminding me that law needs to be applied equitably and fairly across the board, and that you're not asking for anything else than that.
They're allowed to respond to 80+ page motions and say, I need time. That's normal. And the other thing that, again, not everyone thinks about it the way lawyers think about it.
Mm-hmm.
Client's not incarcerated. Okay. That's a big change in analysis about anything.
Yeah.
When someone is in jail and, believe wrongfully and all of this, that can change your thought process about let's move this along and whatnot. Okay. But there is a difference. I mean, it's not a reason to drag something out for 6 years, but that is a game changer. Okay. And it can impact all kinds of things. And so you go to that other case, that's kind of a fiasco, that King case, whatever it is.
Yeah.
County, that's a different issue. And you know what? They got him out because that case was dragging through prosecutorial non-action. And what happened? He got released. So what happened? Now it's kind of, it slows down a little. There's a lot going on here. And I guess, I don't know how we got down this path, but like, there's no one's complaining about, we went to court and nothing happened. We filed a motion off calendar. They're allowed to respond. And the other indictment literally has no prosecutor. And the judge says, you better find one or else. That's called normal. That's how lawyers argue, lawyers respond, and judges deal with it. Nothing abnormal happened last Wednesday. I know it was built up to be
a normal judge.
Now, again, December 5th, if we're arguing a motion to dismiss, Well, maybe that's your popcorn day. That ought to be pretty interesting.
I'll be there, baby. Bells on.
That's
To everyone.
thing, but nothing happened this past week that's abnormal. Well, in the courtroom itself. I mean, the events that led to what we're discussing are anything but normal.
Oh, yeah.
Everything's fine.
Yeah, everything's great. Okay, so definitely December 5th, mark your calendars, loveys, because that will be a good like a good hearing, I believe. Now, there was an update that I wanted to just like scratch your brain on for Sandra Birchmore. Well, not really Sandra Birchmore, but with Heel kind of not being able to be a police officer in the state of Massachusetts anymore. Did you read that?
I didn't read it. I mean, I saw it vaguely in passing. So in full disclosure, I really don't know anything about it.
Okay. Do you mind if I go say something about, do you mind? Okay. Just because I wanted to, I wanted to ask you, we don't really need to read it, but I was just saying, like, I wanted to ask you, he's a figure in the Birchmore case, but he didn't have alleged ties to any behaviors or inappropriate relationship when Sandra was underage. He didn't meet her until she was a young adult, right? And changes it, right? But not whatever. But like my concern, or what I wanted to specifically ask you about, was that I don't appreciate, or I don't understand how we are able to go how these post hearings, right, or whatever the frig they are, that they allow people to do this order to how they're allowed to stop working in the Commonwealth, but they could go and get a license. They could go be police officers in another state. How is that possible?
Well, again, you kind of have to play it through logically. I mean, it's a free country. You can try to do anything, right? I mean, you can be a convicted murderer who somehow gets out of prison, and you can go try to become a police officer in another state and say, I'm qualified. And they do a background check and they say, yeah, you know what? There's kind of a disqualifying factor here. You're probably not cut out for this. If this guy were to go to some other state and try to become a police officer, and they realize that you were basically banned from law enforcement in Massachusetts because of your role with this, I mean, who's hiring him? I mean, again, on a practical level. So to me.
Well, that's what scares me, though, is because on a practical level, they are hiring him. They are. And like in Arizona or wherever else the friggin' other Farwell brother went, like you could go and be a cop in other places. And I think that it's unsafe. And I think that I feel like that should be a national database. And it's like not just the post commit, like pardon me, but fuck that. If you have been, even if you've given up, you've voluntarily given up your licensure or your certification, then you shouldn't have it anywhere else. Because you have skated and not been able to get charges, or you haven't had to go in front of the board because they gave you an out and you took it because you're a slime ball.
It raises interesting questions.
Sorry.
I mean, one is, of course, you ought to address it with the people who ostensibly would hire him and cover that and ask the difficult questions. The public will be outraged if they know all of that. The other thing, which is interesting, is, is there a full faith and credit constitutional issue? For example, you have to respect the driver's license from one state to another, right? If you have a license in Massachusetts, you have a right to drive in Arizona. Should there be an issue that if a Massachusetts commission does this, that the other state should recognize? I mean, there's all kinds of issues here, but on a practical level, if this guy tries to go to another state, whether it was Arizona, New Mexico, whatever you said it was, somebody said it's New Mexico, well, then what you do is you cover it and you address it in New Mexico. And I'm pretty sure that the people who live in New Mexico and government officials in New Mexico are going to say, are you out of your freaking mind? Absolutely not.
Okay. Yeah. And I know that we don't have any kind of say in any of this, and because of all of the unions, and that unions were good, and they were good for a long time, and all of our police officers, like my father benefited from the Mass State Police, from the not Mass State Police Union, but from their police union in Waltham. And like, I get it, but I feel like they have so many outs, or so much, like the representation has prevented wrongdoing from ever being acknowledged. And to have this many outs, Mr. Bederow, feels like a concern for public safety, for you to be able to, like, either, I don't know, retire with your fucking full benefits and just get out because we don't want you here anymore. We're going to give you early retirement. I mean, the shit that they have done in certain cases is unbelievable. And they've worked around in order to protect that badge and protect that cop, and not protect the public, and not protect us as in the communities, that bad things have happened. Like, is there any, I don't know, any way to not say anything about necessarily the unions, but like, would there be someday an ability to get all of the states on a same page, and be able to have like a red flag list of some sort?
Again, there's constitutional considerations. I mean, can an agency in the state of Massachusetts make a finding that is binding on 49 other states when somebody applies to become their civil service? It's complicated.
Yeah.
Okay?
Right.
It's absolutely complicated, but it shouldn't be, in a practical sense, that complicated, because it'll show up in a background check. It ought to be addressed. And in what world would, the New Mexico State Police, or, the local police agency hire this guy with that? And if that were to happen and the public became aware of it, I don't think it would last very long, because I mean, like another perfect example is, someone like Proctor, right? I mean, if that guy went for a job in another state, how can he possibly do anything on behalf of any police agency other than clean toilets? I mean, you can't put him out on the street. I mean, it's poison. I mean, whether you like him or not, I don't know who does other than his family at this point, but you know what I mean? Like, whether you got a raw deal or not, the reality is he's poison. You can't have him out investigating cases. And this guy who's mixed up with this just horrible, horrible thing that happened to Sandra Birchmore, it's the same kind of analysis. I mean, I don't think it would last very long, even if it did.
Yeah. And again, like, you have to look at both sides, right? So you're saying, I can be upset about it, but at the end of the day, he does have that right, and his civil rights and his constitutional rights trump any. And he hasn't been, and he was given a slither out, right? So he hasn't been convicted of a crime, right? Because you were given a fucking option.
The way America functions politically in terms of governance, it is federalism, right? There is a federal government and there are 50 states, and most things are left to the states to agree or disagree. And all I'm simply saying is it gets complicated to allow one state to make a ruling which can necessarily impact what another state does. I mean, like, I'll give you an example of this. You see this in like DWI simple cases all the time. Somebody gets convicted of DWI in New York, and they have a New Jersey driver's license. Okay. The New York court can't suspend or do anything with your New Jersey driver's license. All they can do is suspend your right to drive in the state of New York.
Yeah.
But it's up to a New Jersey court to do something with your license, and we'll notify them and we encourage them, but we can't do it. It's kind of similar. I mean, if this guy were to apply for a job in New Mexico, you'd like to think it comes up, and the Massachusetts people send it to the other state and say, this guy's bad news.
Right.
But different states have different rules and different limitations on their powers of government. I mean, that's just basic constitutional law. I mean, but it's a real thing.
Yeah. Nope, that 100% makes sense. And again, they moved no, I don't know when his next I was thinking about Farwell when his next scheduled hearing was. I thought they moved it. They did actually postpone the last one. And Kelsey Fitzsimmons, she was supposed to have a hearing this week too, but that did get actually moved to the October 5th, I believe. So I'm going to be doing a stream tomorrow, Mr. Bederow, on just the medical aspect of like what has been released, because it's very important to me to discuss why the request that was made in the initial bail conditions that was completed by Kelsey, just not in the appropriate time frame in which they wanted, and did cause extensive amounts of pain for her. Why that would be. And I know that everyone would say, oh, well, duh, Kim, she was shot in the chest, but there is additional, there is much more medically to that, and your lung capacity and what it is asking you, what that test is requiring. So with that being said, I haven't talked to you really about it at all. And I know that you have had a little bit of an opinion. Do you have any opinion about what is kind of transpiring at this point as we await the next court trial for Kelsey?
So there are two kind of things about her situation, which I think, have to be divested. There is, what the hell happened factually about why she's full of bullet holes, and what, if any, criminal responsibility she has or doesn't have, which I don't know enough about it. My comments on that are the same as they were a couple of weeks ago. There appear to be red flags, but by red flags, I mean, I'm flagging issues of concern. I don't know. I'm not involved in that case. I mean, obviously I know her lawyer very well, but I'm not involved literally. So but I'm familiar generally with it. I'm familiar with that a grand jury was unimpressed with the original charges. That's a red flag. You can go on and on. So that has to play out very different from the second layer to this, which is the bail hearing that she had. I have heard the audio tape of that.
Oh,
that was one of the most disgraceful.
Agreed.
I mean, we're talking about like judicial temperament, being reasonable, being fair, and whatever. That felt like a Soviet hearing. That was terrible. Not accepting evidence as hearsay in a bail hearing because, treating a probation officer with that level of disrespect, treating lawyers with that level of disrespect, not really recognizing, in my view, the issues, the fact that there was no bail violation. I think that's another point that's lost. It wasn't like they were coming in and that the defense was taking a defensive position saying she didn't do anything wrong. She didn't do anything wrong. The probation department was supporting the defense, which, by the way, that happens about 5% of the time.
Right.
If that, just generally, probation is an arm of the court.
Yes.
Generally, they're, again, circumstances can change from case to case, but you don't usually have them agreeing with the defense. But so the idea that the alternative was, well, you're not compliant and you're telling me you won't be compliant, notwithstanding what you allege are physical issues that I don't necessarily credit from a letter from a judge and the testimony of a probation officer. So therefore, the only alternative is to lock her up at least for, several weeks while this gets sorted out. I thought that was.
And the kicker, right, Mr. Bederow, was the dangerousness. It was not on. She was like to the public and to the other officer when she was the one who got shot. Like, I go, what the I go, oh my God, this is insane that you were just like, because of her dangerousness. Are you out of your fucking mind?
I mean, look, the dangerousness,
the
dangerousness analysis in the first instance, you would absolutely factor in, there's issues going on. She does have a firearm. Again, factually, I'm not here. I don't know where she pointed it. I don't know if she pointed it. I understand an original finding that there is some degree of dangerousness, and the way we're going to satisfy this to let her out is to satisfy these conditions. And one of these conditions is we have to satisfy ourselves that she's not consuming alcohol. Okay, whatever. And she was complying with that. Now, admittedly, it was difficult, it's painful, and the defense had the temerity to say, can we do this in a different way? Still want her to demonstrate to the court that she's compliant, not consuming alcohol, but she can't, do this because she's, been shot and it's hard to breathe and it's tantamount to torture and da-da-da-da-da. And the judge's position becomes, well, if she can't do my condition, you're not proving to me to a satisfaction that, this is, the judge thinks this is all bullshit. She thinks this is like some kind of scam. This is the third time you've come here trying to do this. She doesn't believe the defense.
Right.
She doesn't believe that there is in my view, a fundamental bias going on here. And she says, well, if you're not going to do it the way we ordered it, and you're telling me you can't do it, well then, okay, you're non-compliant, so I find you dangerous. That feels out of the Soviet Union from years ago. That just feels ridiculous. She's not dangerous because she's telling you it's difficult to do it, and we would just like to do it in a different way, but we're trying to satisfy Your Honor's condition to find suitable for release. And most judges in that situation would try to find a solution, not say, oh, you didn't meet the standard, you didn't do this, you didn't present this, so on a technicality, sorry, back to jail.
I can't. The panic that I literally felt, okay, and just as listening to it, and you could hear, and how much did your heart break hearing her cry, and then Mr. Bederow say, he immediately was like, I'm going to the Supreme Court, because he was like, this is a malarkey, basically.
One of the things that was interesting to me, obviously, and if they do that, they do that. Again, probation is essentially an arm of the court. 99% of the time at any kind of hearing like this, the judge is going to look as the most credible witness in the proceeding, the probation officer.
Of course.
And in this case, the probation officer was, I don't want to say advocating for the defense, but agreeing with this. But also, there's another component to this. The probation officer is also the so-called expert. I don't mean expert in a legal sense of testifying as an expert witness. They're the subject matter expert on how this works. We do this every day. And 99% of the time, a judge will defer to the factual expert because they understand and they deal with this and they're saying, we're okay with this. We can arrange this. We can do this. And her position was, I don't want to listen to your hearsay, but if you're going to testify, I don't care. None of this impresses me. And I don't really believe the doctor's letter. How do I know this is accurate? There, to me, appeared to be an appearance of actual bias, just for whatever reason, that if you're not going to do it my way, I don't want to hear about any of this. You're going to jail.
Wow.
That's how I see it.
Yeah. And she said something about the judge was I believe of what I heard was she was like I didn't say that to the probation. Because whatever she actually said, and there's like a recording of it, she was like, no, I didn't say that. And I'm like, Lady Jane, you need to, you got to check yourself before you rickety wreck yourself, because you're on recording saying this and on record, duh.
I mean, look, her demeanor. She was agitated. She was angry.
Yes.
Dismissive. For no reason. I mean, at the end of the day, whatever the ruling is going to be, as long as you rationalize it and explain your concerns, but that's not what it felt like. It felt like when they went back for that hearing that she came into the proceeding like this, like ready to go. And no judge should ever be, whether it's real or an appearance. I mean, you have to appear and be actually unbiased, and I can tell you her appearance was not one that appeared to be, to me, unbiased. It appeared locked and loaded, ready for battle. And, you know, if you're not going
And
to
she
do
was looking for it. Like you could hear her, Mr. Bederow. I swear to goodness gracious. She goes like this. She asked Tim Brado, Mr. Brado said, how so you're saying that this is torture to her. You're saying that this is torture to her. And then she goes out into she takes a 5-minute recess. She comes back to chambers and she's like, because of this torture, right? The way she's even saying this, I'm like, like, but he was just saying, like, yes, this is not, well, I'm saying he was saying that specific method. And I'm thinking to myself, I go, why don't they get Quest Diagnostics? Why don't they get, we could do blood draws for Christ or a urine, anything that they wanted for the alcohol, right? You don't need to do this gram. Why can't we go another route here? And another thing is that when this was agreed to, Mr. Bederow, nobody did a pre-testing prior to her being not discharged, released from jail. So it's not like she was doing that. Do you know what I mean? So you don't know what you don't know. And of course, you're going to say, fuck yeah, to all of them. Any of the conditions that you asked me to do, I would have been like, I will also jump through a hoop. It could be on fire. I will figure it out because I need to be out of jail.
Problem is, I mean, you just expect the judge to be practical. And again, you have to also go on the current landscape of the case. There was a previous finding where the judge, considering her dangerousness and the legal standards, was satisfied that, notwithstanding my view of dangerousness, that there is a basis to allow her to be released. Okay. So that's the landscape that hearing took place in. Defense comes in and says, we'll do whatever we have to do, but is there just a different way to satisfy everyone that she's not consuming alcohol? We're not looking to release the condition. Just how do we work it differently? And again, this is at a time when the judge had already determined, I'm okay letting her go if I'm satisfied she's not drinking, amongst other things.
Yes.
Okay. So forget being a lawyer. This is why the public has no confidence in how the system works. I mean, this is not so much a legal thing as a, are you freaking kidding me thing? Okay. She's out, right? She's literally not in jail. They're asking to modify something because she's full of bullet holes and it's hard to breathe and do this and do that. The medical people support it. The probation people assist it. And the judge says, basically, if she can't do it my way, I don't want to, you're not presenting me what I find to be a satisfactory other way, then I find her dangerousness, jail. That's just forget the law I'm not going to say forget the law. Obviously the law controls, but people see this, and this is why everybody just looks at the Massachusetts, we're past Norfolk County. I get it. But just says that this place comes off like a joke. And this has nothing to do with whatever she did or didn't do criminally, okay? In terms of whether the charges as they exist now, as they've been reduced, are warranted or not. I have no idea. I have concerns about it, but I really don't know.
Yeah.
But the idea that she has to be jailed with postpartum depression, away from her child, it makes it impossible to prepare a defense when you're in jail. Not impossible, makes it much more difficult than if you're meeting with a lawyer in an office or whatever.
And how about her healing? Well,
that's a great point too. Her medical care, the need for surgery, all of that because of this issue, this ticky-tack issue of how to test for alcohol, that this is the deal breaker that requires you to be sent to jail. It's bad enough that that's the ruling. But when you put on top of that the nastiness, the lack of judicial temperament, what appears to be the pettiness about the evidence, the dismissiveness of the medical testimony and the probation officer, you put it all together. And this is why all these people are running around saying, justice for her.
Yeah. Yeah. I do feel strongly that this case is very concerning to me on a lot of levels. And I just want to keep covering it and to keep keep eyes on it because
Let me be clear
justice
too.
is deserved.
When I say this too, and this is where, I mean, this is the big problem. This has nothing to do whether this woman is literally or legally guilty or not of committing a crime that required a different police officer to shoot her. Okay. This is purely on the issue of dangerousness and whether she was warranted to be released or not. And this is a huge, huge point. The judge released her. The judge found conditions that would satisfy her concerns about dangerousness. And really, one of those conditions was just don't drink alcohol and prove it to me.
Yeah.
And she did prove that. She did take the test. They asked for a minor modification on how to establish that.
Yeah.
And she said, I don't like this. You're dangerous. Back to jail. That's ridiculous. That is unjust.
And on that note, I thank you, Mr. Bederow, for joining me for this Sunday service. It is after 10 a.m. and you have what shit to do before the Patriots kick off at 1 p.m. Eastern Standard Time. Can I ask you something? And you can say no, or you can say, it's pending approval. Next Sunday service, Nurse Kim, Mr. Bederow, 8 a.m. sharp.
Well, I don't know. We have to look at the calendar. What's next Sunday?
Look at the calendar. Oh, I don't know. I'm putting you in. I accept.
Sunday, October 5th. Probably.
Probably.
But
Probably. Are you leaning towards timely Kimberly? 8 a.m. sharp.
Well, I like early because, as you said,
I know you do.
Shit to do. And I budget my time, as you know. And on Sundays, let's start this the right way. What time is the Patriots game next Sunday? Is it? See,
I don't know.
Got to work backwards.
These are things. Let's work backwards. I'm right here with you.
So
we will find a way.
What is? See, next Sunday the Patriots play the night game at Buffalo next Sunday. So.
Is that okay? Can we still? Or are you?
Well, I still like early because, as you said, I have. Shit.
I know you like.
We're on a time schedule. So probably 8 o'clock is good.
I love it. I'll be here.
Better you start at 7:55 than 8:15. I'm very
7:55. Bells on.
I keep a very rigid schedule.
I know you do.
Well, by the way, when I say rigid schedule, I don't mean like Bob Alessi type schedule. Nothing like at all like that. But you get the point. No,
I do get that. And I will say that the best pep talk I've maybe possibly had in the last 10 years was me sending the link to Mr. Bederow, and immediately he jumps on screen and goes, "Hey, get your shit together." Yes, Mr. Bederow. Okay, you are the best.
I did that. I did say that, but that was meant to be tongue in cheek.
Of course.
But it did have that passive aggressive, like seriously, like get your shit together. But
also, time is money, and I pay him none. So there we go. I love everything about you.
I'm not a grifter. I do this out.
I'm a grifter.
Out of friendship and educating people.
I know. Oh, friendship and education. All right, you have the best day, and I'll text you about the Patriots. Who do you think they're gonna? How much do you think they're gonna win? Did you put any bets out or no? You don't.
I don't bet. I'm not a better. They're playing the Carolina Panthers. They're an awful team.
Win. Yeah.
Well, I'm not sure. Sure how good the Patriots are, but this is a game where if you have any hope at all of them having a respectable, credible, and perhaps playoff-ending season. Yeah. This is unlosable. I mean, you cannot lose to this Mickey Mouse garbage team at home. So, I think they'll win today. Next Sunday night is at Buffalo. That probably will be ugly, but that's okay.
But also a good game. I like the Bills. I always like when we play them. But I mean, granted, I don't know.
I mean, how do you not feel bad for Bills fans? I mean, historically, 4 straight Super Bowls, each one getting worse. That they went from wide right to blown out worse, and then humiliated. And they've had, they're like the lovable loser.
Bills Mafia.
Yeah, but they're incredible. I mean, I've been, I went to law school in Syracuse. So if you go to football games, you go to Buffalo. And I will say this, you want to see a strange, hardcore crowd, go to a Buffalo Bills game. And this is, again, in the 1990s, but they are far and away the most blue-collar crowd I've ever seen. They are, I mean, this Bills Mafia thing is real.
I love them.
Half the fans are wearing those god awful like tiger pants. Remember that people used to wear
Yes.
in the 90s? Oh my god.
Yes.
And the other half are wearing like firefighter like type like those and 97% of them are just drunk by,
Oh yeah.
you know,
Tailgating professionals.
but I got to tell you, incredible fan base. And
Yeah.
it's Buffalo. It's really all they have, other than great food. Not just wings, by the way. The Italian food in Buffalo, I have to tell you, it's sneaky good. Like old school Italian.
I know this.
And what do they eat those things? Beef on weck. Those are incredible too. But Buffalo is an interesting place. But Buffalo Bills fans deserve better. They deserve. I mean, I don't want them to win because I want the Patriots to win. But I will tell you, I would love to see if the Patriots stink, Buffalo get their shot, because I can't imagine what that celebration would look. They would burn the city down. I mean, they would just destroy it out of sheer euphoria, and they deserve it.
I love it. I love it. And I secretly okay, so clearly Pats are my first team. Bills are somehow my sneaky second. And it's only happened in the last 10 years because I never liked them before. I was always a Dallas, whatever. No, never mind. But like in the last 10 years now, I'm like, they're like my cousin that I'm like, hey, all right, if we can't, if Tommy can't take it home, then I'd like him to,
Yeah.
and you're secret rooting for them no matter what. So
I don't root for them. I don't like or dislike
no,
them.
they're people though. They're like community. They have a good, how like this. Okay, so the Yankees suck and they always will. Okay. And I don't care. I'm sorry. I can't. The Yankees fans suck and they're mean. And anytime I've ever gone to Yankee Stadium, they have been mean to Red Sox fans.
Mean is not the word. So in the heyday of the most recent good Red Sox Yankees rivalry, so I'm talking in like late 90s until like through 2004 and beyond. I mean, that was the peak where they were both good and I would, go to a lot of games when they would play in Yankee Stadium. I mean, it's just a way ride up. And at the time, especially when, on a prosecutor's salary, a lot of those times, you just get tickets on StubHub or whatever.
Yeah.
And the cheapest seats in this is the old Yankee Stadium, which a lot of Red Sox fans used to call the toilet, because that's what it was. No, I'm not kidding. Like, that's what it was called. The cheapest seats, or at least the most affordable seats, would be in the right field bleachers. Now, if you know the old Yankee Stadium, you would know that the New York meathead fans at Yankee Stadium are in the right field bleachers. And my God, sitting there during these games, including 2 games in the 2004 playoffs, including the Pedro Martinez, who's your dad? I don't know if you remember that whole fiasco.
I do.
Where he lost and he said, "Oh, the Yankees are my daddy." And then the next night, oh God, sitting there, the things that they would say, the beer showers that you would take. And the most dangerous part of those games, by the way, would always be not even getting yelled at by a lot of this trash that would live in the right field bleachers. It was leaving. It was going down the ramp after the game where you were really at risk of just getting whatever. But
a haymaker.
I also sat in 1999. This was by the right field power pole in the upper deck at Yankee Stadium, which is like, 20th story building basically up there. There was a game in 1999 where the baseball fans will appreciate this, the real ones, where Pedro Martinez pitched, and this was peak Pedro Martinez, like in his prime.
Yeah.
And he threw a one hitter, and it was one base runner the whole game. And it was actually a home run by Chili Davis. He struck out 17. He didn't walk anybody. The Yankees literally had no base runners. They got one hit. It was a Mickey Mouse home run.
Yeah.
And it was the most incredible in-person, most dominant thing I ever saw.
Oh.
And it was just, what are you doing? I'm telling like war stories of baseball, and we're
I'm
looking.
here. Sorry.
It was just the most incredible thing. And if my memory is right, I don't think the Yankees hit another ball out of the infield that whole night. And yeah, it was in September of 1999. Absolutely. And it wasn't a perfect game. It wasn't a no-hitter. It wasn't even a shutout. But I would tell you, it had
Electric.
the single most dominant performance. And if you knew, and of course, Pedro is like Mr. Charisma. I mean,
oh yeah,
Mr. Charisma. And it was just watching that, even the Yankees fans were just in awe back then. And it was a good time. So yeah, I don't know how we started on Yankees,
the days,
but the new Yankee Stadium has no character. It has no charisma. There's no home field advantage for them. And if you're a real baseball fan, you know that in the last 20 plus years, every team is trying to build these like modern, basically modeled off Baltimore, off Camden Yards, nice old fashioned park. And, I've been to many of them. If you go to the one in Philadelphia, it is.
Oh yeah.
The one in Pittsburgh, unbelievable. Baltimore, even Washington is nice. I've never been, but people say San Francisco is just incredible. But the new Yankee Stadium, it's just a new toilet. It has no character, no experience. It's still in the South Bronx.
It's just a new toilet. I can't.
The bars around Yankee Stadium are still under the elevated subway.
Yeah.
You want to really, it's just there's no character. It's just this stale, which is shocking because you would think when they were building all these modern parks, it's just New York City arrogance. You would expect that the new Yankee Stadium, because they're the Yankees, because it's New York, this one has to be the best ever, right? We're going to make this one, and it's awful.
That sucks.
Sucks for them, yeah.
Yeah, not for us, but
no.
Yeah. Well, thank you for sharing. And I will never forget the 2004 season. I was literally 18 years old, and I remember thinking that the Red Sox were magic. And my Nana died in October of 2004, right after they won, right after the boys won. So Nana Phyllis, I always think of her almost every day of my life, but like specifically in Soxtober, I get very very sentimental.
A lot of people have those stories, and now we have to talk about 2004. So
okay,
work can wait because here we go. So living in New York City in 2003, and of course in the late 90s, the Yankees are winning the World Series every year. Just sucks. Okay. And if you go back to my childhood, which is well before 2004, 1986 was just traumatic. I mean, that was we're not going to get into the whole Bill Buckner.
Yes.
But then you go to like 2003, okay? And it was 1978 all over again. And I remember watching Game 7 at that time, I was living in Gramercy, had some friends over, and the game's going great. I love it. Everybody knows about the Grady Little, and Pedro was done and he left them in, and everybody knows about Aaron Boone, Tim Wakefield, and all of that. And I just remember watching that and just jaw on the floor. Just enough of this, like this. And now you live in New York. How do you go to work? Because it's just euphoria all around you. Then that was the off season where, okay, they're going to get, at the time, everybody wanted him. It turns out, my God, aren't you glad they didn't? Alex Rodriguez. And what happens? He ends up going to the Yankees in that offseason. And then the Red Sox got Curt Schilling, and that was okay. And then you go to 2004, right? Here we go.
Yes.
And another game I went to that year was right around the trade deadline of that season. There was another one of the most incredible. I mean, I've seen a million of these games in person, but one of the best ones ever was this game. And this was the famous Derek Jeter Nomar game.
Oh, I know it. I know it.
I loved. Sat on the bench and pouted. Okay. And they kept showing him in the Red Sox dugout just pouting. And Derek, this is the game where Derek Jeter dived into the crowd, was actually sitting not far from there, bloodied his face, caught the ball. I don't know if you remember this.
I do.
And that was that was the moment, okay? Because what did they do? They traded him, and they changed the whole dynamic. And that season was incredible. I was actually at the game in Boston where there was so much Red Sox aggression release where Jason Varitek face washed Alex Rodriguez. And that was another, just thank God. That's like one of those, I'm so glad I was there to see that.
Yeah.
But then you fast forward to the playoffs, okay? And, it's 3-0, right? And they lost 3. I'm pretty sure the final score was 19-8. I mean, it was just humiliating.
Yes.
And, living in Manhattan and people just getting shit from everyone, and it just sucks, right? Everybody knows what happened in game 4, right? And then game 5.
Yep.
It was that extra inning game in Fenway Park. I remember watching it at a bar in Manhattan with some people from work. House money at this point, I expect the worst, but that David Ortiz gets the walk-off hit. Now there's going to be a game 6. All right, well, this is at least interesting, but I'm not doing this. I'm not allowing this, okay? And then game 6 was the bloody sock Kurt Schilling game. And then you realize, okay, like, wow.
It was fated.
And then there's a game 7, but part of you still says, this is the most Red Sox thing ever. They're doing it. They're pulling me back only to
break our hearts.
Okay. So I remember game 7 very well. Was not there, watching on TV. And David Ortiz hit a home run in the first inning. They're up 2-0. All right. And then later on in that game was, I have to be honest, one of 2 most euphoric sports screaming, go crazy like moments that ever happened. Okay. And everybody knows what it is. There was a Johnny Damon upper deck grand slam.
Yep.
Leaf put them up 7-0. And I just lost my shit. I couldn't. I mean, this was like cathartic, right?
Yeah.
I mean, they weren't losing it. You knew it. I mean, that was just the biggest let it all out and club these Yankee fans in the head moment finally. And it's going to also be. It's not just that they're going to win, but they're gonna stick on the New York Yankees the worst collapse, choke job, laughing stock
franchise. Yep.
No, in the history of professional sports. I mean, this is the ultimate choke job by the team that never chokes.
Yeah.
And then of course you say, well, now the ultimate Red Sox thing is going to be to do that. But now they blew their load and they're going to lose the World Series. And this is like the most Red Sox thing ever. And then what do they do? To their credit, they go out, and sweep the Cardinals. And, you were saying how you remember watching this. So there was a famous bar in New York City. It's no longer there. It's called the Riviera. And it was in Greenwich Village. If people know New York, on Christopher Street and maybe 7th Avenue, whatever it was. And they were the smartest marketing thing. They're like, we're going to be the Red Sox bar in the middle of Manhattan. And they actually showed footage, which is disgraceful. They should have been showing the Cask and Flag and in all those places. But they would show the New York bar in the World Series where a ton of people were going. But I remember game 4, which was going to be the clinching moment, going to a bar that I assume is not there anymore in the Upper West Side where I lived that time, called Blondie's.
Oh.
And it was on, if you know New York, 79th and Broadway. And it was filled with the whole, people are going crazy. And when they won that, the idea, and I mean, it was filled with Red Sox fans who, as you can imagine, there might have been, a lot of that going on.
Yep.
And probably the only thing that was cooler than celebrating in Boston would be going outside, on Broadway at what amounts to 1 a.m. or whatever. And there was a ton of Red Sox fans out there, just complete lunacy on enemy territory, right? I mean, this is like, the Upper West Side of Manhattan, running around and just euphoria.
Debauchery. Yeah. Love it.
And I don't know how we got down this path, but like that was the other moment, by the way, to match the Johnny Damon moment,
Okay.
Malcolm Butler in the Super Bowl.
Oh.
At the time that happened, so I had a broken ankle, like a shattered ankle. So I was in a full cast, and I'm watching downstairs in the theater that we were talking about, like
coming
6
over.
hours ago.
Yeah.
But I mean, I'm in a full cast, crutches. I can't, I'm like leg extended. But when that happened, your brain is focused on that, not like, dude, you can't walk, right?
Right.
And so that happened. And I'm sure, like every other Patriots fan watching that, what do you do when you see this? I mean,
Right up. Yep.
The Super Bowl was over in a loss, and just literally in a second, it went from 99.9% chance of losing to 100% chance of winning, like that. So you're trying to get, and you're like, oh, this is kind of melodramatic because, the leg's not cooperating. So I'm just kind of,
I'm a hobbler. Yeah.
Stuck on the couch with a dog looking at me like, yeah, you're not going anywhere. But
her name was Lola. She
no,
was a showgirl.
Lola was this was not Lola or Winnie. This was Caesar, the yellow lab. Yes.
Well, to all the Caesars, to the Lolas, to the Winnies, to the Kinos, to the Mr. Mark Bederows, and to the Nurse Kim and Lovios. We love you. Have a wonderful Sunday. Thank you for joining us for Sunday service. And next Sunday, 8 a.m., mark your calendars. Mr. Bederow and I
set an alarm.
Are on the fly.
Turn the computer on a little early,
Yes,
do your sound checks earlier. And,
Sound check, 1, 2. I appreciate you. Bye-bye, lovies.
Bye.
All right, great job on the news.
Thank you.
We will, Courtney and I will share what happened when we went to dinner last night, Sunday dinner, coming up. And as